Through on behalf of Mr. Ryan Busick, number 84554. Mr. Busick, please state your name for the record.
Ryan Michael Busick. State time for second pieces.
And Your Honor, at this time, I have made a request for the video and digital discovery in this that has not been tendered to me yet, so we'd be requesting an adjournment of the PCC.
There would need to be a green sheet. Yeah, we need to not we'll get green sheet to fill that out.
Sure thing, Your Honor.
All right.
Also, when you discover the opportunity to discover investigation counsel, and they also yesterday, I've not received it yet, which should be enough.
And Your Honor, we would like to address bond when the court is ready.
You want the 26th or the 3rd, counsel?
Give me just a moment to check my calendar, Judge. The 26th would be fine if I could be accommodated, say at like 10 a.m. or later.
Well,
I have an
you'll likely be in court toward the afternoon, but I will send it tonight, and then we'll place you into a block. You tell me what you
Very good. Yeah, I do have a hearing.
In custody, you'll be in the 9 o'clock block.
Okay, I may just be tardy for court then that day. I'll be coming directly from.
All right. Yes, that's about.
As to bond, while I know the court heard me 2 days ago, I would note that, due to Mr. Busick having no record, these last 2 nights in jail have left an incredibly strong impression on him. Not only the seriousness of this case, the importance of following all conditions of any bond or any court order going forward. He would like to get back out working so he can save his health care for his children and for himself. He would like to pursue a mental health evaluation. I have talked to clinical therapists, one named Virginia Dawson, who works closely with many courts in Oakland and Wayne County, and she's worked with my office for years. She has experience in 48th and 16th District Court. I confirmed that she has appointments that would be available to him every single day next week, depending on his schedule. So we would accordingly renew our request for a cash bond that Mr. Busick can afford of $25,000, 10%, Your Honor. With the tether, obviously.
Yeah, I believe the court knows where the people see their bond. It's going to object given the fact of the bond violation originally, and then the fact that I believe the bond that is currently set in the meaning all of the state previously on the emergency bond, as well as the bond violation that came out this bond.
The court would incorporate the findings a couple of days ago addressing the emergency bond. The emergency bond filed on behalf of people, and particularly noting that after the point of ruling, defendant's conduct, I don't think would lead the court to believe that the defendant would be able to follow all conditions set without some cash component, significant cash component in place to try to assure his compliance. And also the court does believe because of those actions, the defendant does pose a risk directed to the community. And so therefore the court will deny the defendant's motion. In this case, once again.
Do you consider a 10% provision on the current bond, Your Honor?
You asked me that yesterday 3 times, so the answer is no.
Fair enough, Your Honor.
All right.
I hope you and your staff have a good afternoon. Thank you for allowing me to make a record, as always.
Thank you. Court does call the case of the people versus Wesley Green.
Good afternoon, Your Honor. Wendy Barnwell, P42 505 on behalf of Mr. Wesley Brand.
Well, sir. Wesley Brand. This is the hearing that is requested by the defendant regarding the violation.
Yes, Judge. My client at this time wishes to waive the bond violation hearing.
The events of the violation.
Yes, Judge.
Regarding contact.
I didn't hear you.
Regarding contact, yes, kind of.
Regarding the phone calls. That was the question.
Yes.
Yes.
Court will accept the defendant's confession to the violation. I think his bond currently is set to no bond violations or alleged violations which made in the hearing. Where do you want to go from here in this case?
We're asking for a preliminary examination, Judge.
You have all discovery counsel.
Yes, Judge.
People have their witnesses available on the 24th. Does the 24th work for you, counsel?
It doesn't unless it's in the afternoon.
It would be all of
Right.
so,
Let me look and see if I could get a better date.
we
You
have
know what?
the-
I'll take the 24th and I'll switch the other date.
So preliminary examination will be sent in person. June 24th, 2025, 9 a.m. before Judge Freshour. Bond will continue as no bond is found. I will open bonds.
Judge, there is one thing though that I wanted to address. My client wanted to be able to call his mother. His mother has no connection to the complaining witness in this case, nor is he going to use her as a method of communication.
People.
I appreciate your interest in it.
Yeah, I'm not going to allow that to happen this point in time. I normally wouldn't have a concern about that. The defendant has already decided that he wishes to engage in activities that violate the state's policy. So I'm going to choose
Notice the tone shift. Prosecutors are laser focused on violations here. In bond hearings, judges weigh two things: flight risk and danger to the community. Given the prior violations, this argument is a big red flag. Could this defendant be trusted out in the community?
Right?
Thank you, Judge.
Court does call the case People versus Holly Brown.
Shilani people.
Good afternoon, Your Honor. Sam Bernstein, Hugh for Holly Brown.
And this was her motion to set aside the plea. I would indicate I don't know counsel. Are you aware of the violation?
Yes, Your Honor.
She's not there.
Doesn't look like it, Judge.
People determined after court, not defendant's motion to withdraw complete. That we should file later and issue them for.
I would just ask, instead of just denying, she just doesn't need to go forward at this time, and she can renotice it if appropriate later.
Well, here's part of the problem. Part of the problem is this was sent to Judge Freshour for sentencing.
Then
she files her motion to withdraw. Since I took the plea, it came back to me. And it's been sitting here while I'm trying to address her motion to withdraw the claim.
if it gets denied, it goes back to Judge Freshour.
Goes back.
I'd ask for it to be denied, Your Honor. Thank you.
So what I'm going to do is, defendant having failed to appear, motion to withdraw plea denied, and warrant will continue out. The bond will be submitted in November. Point because I issued a warrant. It's on the violation. Alright.
Alrighty.
Next.
Your Honor.
Court does call the case. People versus Anthony Burns.
Those who know. And I'm good afternoon. Mr. Brooks, state your name for the record, please.
You're
Last court date.
excuse me. Have a seat. Go ahead.
The last court we counsel to receive a copy of this motion. I don't believe that is counsel or attitudes or rely on that to court, but so to speak, we've got steps is sorry.
Thank you very much for that, Mr. Bengali. Your Honor, I was going to request an adjournment on behalf of my client. I did speak with him. He states that he has not been able to retain an attorney, Judge. He indicates to me that he's reached out to two different attorneys. They've both said that their caseloads are too heavy to take on anything additional right now. He, at the last hearing, did request a month, hoping that we would get that. The court gave us 2 weeks to see how far we've come. He states he only has his mother and his significant other. He has the funds to retain, or he can gather the funds to retain an attorney, but he just has not been able to secure a person who's willing to take on his mom. So he's asking that the court adjourn today and give him a little bit more time to continue working. I was just going to say, in regard to the people's motion, Judge, I know that, there is currently a search warrant that has been effectuated. I have explained to my client what could potentially happen, and people listed that out in their motion. He does understand that. However, Judge, there's no urgency. It's not as if this is a situation where uh, more time would, possibly negatively impact any results that they may get from that sentence when it's received.
Will slightly count.
Okay.
You have to receive other court. I am compliant with that court. You have to read this. Trying to understand what else? You have to then have those people that each subsequent issue by a sample result and we call it one is
And Judge, it should be noted that there is an additional case, it's an A1 case that my office conflicted off of. That is the subsequent case. That is the case that was being investigated when the search warrant was given. So he is. Do you know what you're calling? It's $100,000 cash or surety bond on that, which he is not.
And he's also.
That is correct, Judge.
What I will do in this case is his bond currently is $10,000.
Ouch, no bond. That means he stays locked up until trial. Judges don't hand that down lightly. But when violations pile up, especially with contact orders, the court's patience runs out fast. Do you think losing all phone privileges is too harsh, or exactly what's needed?
No cash surety. And granted, I have not heard the motion, so the defendant seeking counsel, so I won't demand until he's compliant. But I do not think, given his behavior being not complying, at least at this point with the order for that, I'm going to increase his bond in this case to $1,000. I will adjourn the motion. How much more time is he going to need?
Judge, he's asking for past 20 June. 2 weeks, Your Honor.
26th of June. He thinks he can get it accomplished.
That's what he's hopeful for, you, Judge.
And I will adjourn. Probable cause and motion. Probable cause and motion will be adjourned 26, 2025, p.m.
Thank you, Your Honor.
Court does call the case to versus Allen Blue.
Good afternoon.
For the people.
Lawrence Margolis on behalf of Mr. Blue. Please state your name, sir.
Alan David Blue.
Judge, this is the date and time for PCC. We've been working with Ms. Douglas and everybody at the Veterans Court. And I believe this will be a referral to the Veterans Court. So I've been advised that I thought he was accepted, but I think there's more formalities that have to occur. So I'm seeking the shortest adjournment you can give us, because I've spoken with Mr. Ashenfelter, I've spoken with Judge Galbo, I've spoken with Paul Grabeline, and they all are very positive on Mr. Blue and his entry into the court. We signed the paperwork. He met with Mr. Ashenfelter yesterday, 2 days ago. So I guess we're seeking a week.
Well, I only have, because of Juneteenth, I only have 17, which is becoming a loaded docket. And I have, that's on a Tuesday, 26.
17 works for me. Is that?
So the 17th?
Perfect.
You think you can get?
Yeah. And if not, I'll let the court.
Well, so the motion of the PCC, as well as the motion for a modification of bond, will be adjourned to 17th, 2025, 9 a.m.
Thank you, Judge.
Yeah.
See you later. Hunter, would I be able just to provide the court's copy to keep in the file, what may be ready of the VA referral, or do you want that at a different time? I prepared the form thinking that I was going to be referred, that we were going to be referred today. I'll send it again.
Court does call the case of People versus Neil Kessler.
Lawrence H. Margolis Switz, on behalf of Mr. Kessler, who is approaching, please state your name, sir.
Neil Kessler.
We are prepared, or we're asking the court to set it for an exam date.
All right. What about your mother?
Legal maze alert. Even the judge admits this is messy. Here's the breakdown. Circuit courts handle felonies. District courts handle preliminaries. If paperwork isn't clear, cases bounce between courts like a ping pong ball. Ever wonder how often justice slows down just because of court logistics?
So I will rely upon counsel keeping for that work prior to the exam.
Thank you, Judge.
You have all of this covered.
We do.
Would people have their witnesses available 24? All right. Preliminary examination in person will be set June 24, 2025, 9 a.m. That is before Judge Washington.
Thank you, Judge.
Thank you. The court does call the case of the People versus Dantes Williams.
And says on behalf of people, Your Honor.
Brian Bowling on behalf of Mr. Williams.
I am Dantes Marquise Bernard Williams.
Thank you.
Judge, we're here for a bonding violation hearing. Based on my discussion with Mr. Williams yesterday, I'd like to move forward with that hearing.
Very good. You can have a seat. And as I understand, this is a part of a remand from Circuit Court because of the addition or the attempt to add an additional charge.
Assault with a dangerous weapon.
Yeah, felonious assault. Part of that hearing is bond part.
Do I have a moment?
Sure. Each time we meet.
Don't comply.
I don't know. You know, whenever the defense attorney says that to me, why don't we take it back and then guys? Yeah, sure. And then court is taking a recess. Just let somebody know. Court does recall the case versus Dantes for you.
Go ahead.
And on behalf of people.
Brian Bowling on behalf of Mr. Williams, just state your name.
Dantes Marquise Bernard Williams.
Thank you. All right, I've had an opportunity to speak with counsel regarding the case, and there may be clearing that we worked on. Here's the only problem, which I think is both in this court and fine officials. We both want. But the order which sent this case back down to the district is unclear as to the charges you were put over on, whether the jurisdiction on those charges still lies with the city. And again, down here we could do nothing. So what I'm going to do is I'm going to adjourn it to the 17th, go 5 days out. I'm going to make a call with Commission Counsel to Judge Slay to try to make sure and clarify what her reading of her opposed to my own. If necessary, implore her, if necessary, to give us a new order if we need to, so that everything comes back so we can take care of it. Okay? Bill said she was.
Yeah, but no, but yeah, it's like it could have been dealt with in circuit. So I was
Circuit Court, I mean?
yes, so
I don't, let me just say, I don't know what happened up there. All I know is it came back down to this court for a bond motion and for a preliminary examination on additional charges.
Yeah.
So then I only get for bond motion part of it. So, but counsel, Stuart, been working very hard to come up with something that would be a good solution, I think. And so to give that a shot for it to happen, I'm willing to adjourn this out 5 days, do what I can to try to clarify it all and see if okay. If you have questions on it, ask your attorney. car 18. Okay. So bond will continue as it is right now. I'll bring this out to June 17, 2025. All right. Thank you, folks.
Thank you, Your Honor.